All right, let's jump right in. We are tackling one of the most fundamental chapters for your licensing exam, and honestly, for your entire career. It's all about your duties to the Law Society and, critically, the strict boundaries of what you are and are not allowed to do. Getting this right isn't just important, it's everything.
So, to really nail this for your exam, we're going to use what I like to call an exam cram funnel. We'll start big picture, then funnel down to the specific rules and the tricky exceptions, and land on the exact outcomes you're going to see on the test. Let's do it.
Okay, so what's the big idea here? Simple. This chapter basically defines your entire professional universe. It's the rule book for the game you're about to play.
Really, it all boils down to two key relationships. First, your relationship with your regulator, the Law Society, and second, your relationship with the public, which is defined by the services you're legally allowed to provide.
And here's why this is so critical for the exam. They're not just going to ask you to spit back a rule. No way. They're going to give you these messy, tricky fact patterns to see if you can apply these principles when you're under pressure. Knowing this stuff cold is your absolute first line of defense.
So let's train your brain. How do you even know a question is about this chapter? You need to learn to spot the red flags, the triggers and the fact patterns that should make your spidey senses tingle.
This is a classic, but you'd be amazed how it can trip people up. The second you read words like real estate, family law, or drafting a will, a giant scope of practice alarm should be blaring in your head. It's an immediate nope, can't do it.
Now, here's another trigger: any communication from the Law Society. The exam isn't really testing you on the complaint itself, it's testing your direct duty to respond, and to do it promptly and completely. Because failing to respond, that's its own separate professional misconduct.
And this one? Oh, this is a perfect example of the kind of detail you need for the exam. The word assault should immediately trigger a question in your mind. Is this summary or indictable? Because your entire ability to even take this case hinges on what the Crown decides. We're going to circle back to this for sure.
All right, now that you can spot the issues, let's lock and load the core rules you absolutely must have memorized. These are the non-negotiables.
The exam loves to test the difference between these two. A disciplinary suspension is for actual misconduct, bad behavior, and you get a formal hearing. But an administrative suspension, that's automatic. No hearing. It happens because you forgot to do something, like pay your fees or file a report. You have to know the difference.
Think of this table as your professional GPS. Before you even think about taking a case, you have to know if it's in your jurisdiction. Burn these into your brain, especially the small claims court limit of $35,000 and that crucial rule for criminal law, summary conviction offenses only.
You know, the Law Society doesn't just throw rules at you. They give you a recipe for how to think through a problem. You could literally get an exam question about the right process for handling a tricky situation. These 5 steps are that process. And notice step 4. Seek guidance is built right in. They want you to ask for help.
Okay, now we're getting into the details. This is the stuff that separates a pass from a high pass. The exam won't just test the simple rules. It's going to test the tricky exceptions where things get complicated. So your default setting should always be, I probably can't handle this criminal case. The general rule is that almost the entire criminal code is for lawyers only. But, and this is a huge but, there is a very testable exception.
And here it is. This is the key you have to know. For those hybrid offenses, like assault, your power to act depends 100% on the Crown choosing to proceed summarily. If they choose to proceed by indictment, you are off the case. End of story. You have to know this distinction cold.
And this is the other half of the puzzle, right? It's not just about knowing the rule, it's about what you have to do because of the rule. You must, upfront, warn your client about this risk. You have to say, look, I can represent you now, but the Crown could change their mind, and if they do, I'm off the case, and that could cost you time and money.
You've got to know, the people who write the exam, they're smart. They know exactly which concepts are easy to mix up, and they use that to create tempting wrong answers. So let's disarm those traps right now. Here is a classic exam trap. Spot audit, practice review. They sound similar. And yeah, they're both remedial, not disciplinary. But here's the key difference you have to remember. A spot audit is a laser-focused dive into your financial books and records. A practice review is way broader. It's a look at your whole practice management system.
I know I said this before, but I'm saying it again because it is such an easy trap to fall into. Let's say the complaint against you is total nonsense and gets tossed out. Great. But if you ignore the Law Society's emails about it, you can and probably will be disciplined just for that.
Ignoring them is its own misconduct, period.
So, what's the end game? What happens when a rule gets broken? An exam question might give you a scenario and ask you to pick the most likely or appropriate consequence.
And listen, the consequences are no joke. A hearing panel has a whole toolkit of penalties, from something as simple as a fine or more training, all the way up to a suspension or the ultimate career ender, having your license completely revoked.
This is one of those numbers you just need to memorize. 12 months. An administrative suspension is easy to fix. You pay your fee, you file your report. But if you let it go for more than a year, the Law Society can revoke your license. Poof! And you don't even get a disciplinary hearing first. It's a critical timeline.
So when you boil it all down, why does any of this matter? Because these aren't just annoying bureaucratic rules. They are the bedrock of public trust. Trust in you and trust in the entire paralegal profession. Following them protects the public, it protects your clients, and it protects your own career.
And that right there is the key. I want to leave you with this mindset shift. Your human instinct is to ask, can I help this person? But your professional, licensed duty is to first ask, am I allowed to help this person? Always ask, am I allowed to, before you ask, how can I? Make that shift, and you'll not only ace these exam questions, you'll build a long, successful, and ethical career.